Haley Bull in Washington for us. I want to go ahead and bring in attorney and legal analyst Dina Saeg Dahl. Dina, thank you so much for joining us. I want to focus on the unnamed co-conspirators in this case. There are six of them, and there are details under each of them that lead us to believe who they are, Rudy Giuliani being one of them, most of them at least. But there was a conscious decision not to name them here. Why is that? And is this a part of a strategy to see who may cooperate?
Well, we can tell a little bit of what Jack Smith was thinking when he didn't name all six of them. Although, like you said, because of documents out there related to the House investigation, we can pretty much know who they are. And he did the same thing, though, in Florida with the classified documents case. He didn't name the now two employees have been charged, and in the beginning, they were just unidentified co-conspirators. So he's basically giving these six men or and one woman we think a chance to cooperate essentially before they themselves are also federally charged.
Yeah. As is the prevailing thinking around some of this. I'd like to read some of the indictment here and see if we can clear something up. For more than 2 months following Election Day on November 3rd, 2020, the defendant spread lies that there had been outcome determinative fraud in the election and that he had actually won. Now, I didn't go to law school, and I'm not quite sure what a lot of this means. In this context, what does outcome determinative fraud mean?
Well, I think it means that, let's say here, let's give an example in Georgia, when they were talking about, there was being a widespread fraud. As it turned out, they found out that there was maybe only 12 people who voted that shouldn't have voted. So they can't come out and say there was no fraud because technically 12 people fraudulently voted. Whether or not it was because they weren't properly voting. So when they say that is outcome determinative, it's because there wasn't enough fraud. I mean, obviously, 12 people isn't going to sway who gets the electors in that state. And that's why we see that phrase being used in most of the states, is because it's pretty much almost impossible to say that there wasn't at least one ballot voted that wasn't supposed to have been voted. And that's what they're saying. But it wasn't on the scale that could have swung the electorate in any way.
Yeah, that helps clear things up because each time I ran across it, I said, what is outcome determinative? Either way, we should note in this 40 something page indictment, there's a pretty broad narrative here that amounts to just four very serious charges. From the DOJ's perspective, what must they prove in court, and how important is intent for presenting their case?
Okay, that's a great question. Most of the counts do require knowledge. It requires that Trump knowingly, knew basically that what he was saying was a lie, that he actually lost the election, but he was saying that there was widespread fraud, and that without the widespread fraud, he would have won. And this is what he did. And he even did, fake electors. Him and his co conspirators allegedly, he's innocent until proven guilty, of course, had these fake electors based on the fact that they thought it was a lie. So Jack Smith is going to have to prove that Donald Trump knowingly basically lied, that he really knew that he had lost the election because the attorney general, the deputy attorney general, everybody, the lawsuits that he lost, knew that there was not fraud, but he continued anyway. Interestingly, though, one of the counts, the obstruction of a court proceeding, doesn't require knowledge. And that count is what has been used to convict many of the January 6th rioters because they were obstructing a court proceeding. And so that is included. That doesn't require knowledge, but it might be a little bit hard to also have that stick with him because he wasn't physically on the ground obstructing the proceeding, right? The congressional proceeding, like the other rioters were. So it's going to be an interesting mix of between knowledge and other factors that Jack Smith is going to have to prove in order to make his case.
Yeah, with the last 30 seconds we have here, I'm not giving you an easy task. There was plenty of talk about the possibility of forum shopping in the classified docs case. The DOJ decided to go with Florida as their venue instead of DC. Here, they went with DC despite this alleged scheme taking place over several months, at least in 7 different states. Why here, and how might that impact the perception of fairness?
It's common for federal prosecutors to indict in DC. That's their hometown, it's their home turf. It's much easier for them, and so that's why there was kind of this question why Jack Smith didn't even try to do DC. But much of the actions around the election, it makes sense for it to be in DC. That's where the White House is, where he had a lot of the conversations. That's where the January 6th, the Capitol is. So that location makes much more sense. And I think Donald Trump would have a very hard time moving the venue. Here we know that we have a Obama appointed judge versus in Florida, we have a Trump appointed judge. So that's going to be interesting. The two venues will definitely have a different take in terms of the fact that we do have two different judges.
You're good. You did that in about 30 seconds. I appreciate it. Attorney and legal analyst Dina Sayegh Dahl, many thanks. Thank you for joining us. Now, when